Announcement of judgment, item 28, WBC 683, oblique 2017.
Petition is dismissed.
WBC 683, oblique 17. Next judgment, item number 29 with 30 and 31.
Out of these three writ appeals, writ appeal 233 of 2024 is partly allowed in respect of respondent numbers 5 to 12. However, the appeal is dismissed in respect of respondent numbers 1 to 4. The reason is that respondent numbers 1 to 4 were appointed in due process of law. And so far as others are concerned, we did not find them to be appointed in due process of law. And then there is, they have not rendered adequate service. But insofar as others are concerned, the appeals are dismissed. 242 and 215. In 215, they have rendered 28 years, 11 months of service. And in the other case, also there is similar situation. You'll get it after some time. There's some correction, last moment corrections.
I wish to mention item number 40 for arbitration, my lord. Supplementary list.
If we have time, because in second half, we'll be taking up those APSC matters.
And in this matter, my lord, I have filed additional affidavit that may be called for.
Item number
40. 40.
40. Okay.
My lord, I beg to mention one fresh motion matter, my lord, for the first time, my lord, may be taken on Monday, my lord.
You have to the court conference.
Wait, please, my lord. Lordship, I beg to mention item 6 and 41. Your lordship.
Item
6 and 41. In item number 6, we have circulated adjournment petition, your lordship. And item number 41, your lordship may not like to take up this matter.
Okay. Item 6
And 41.
both sides are represented on the prayer made by learned counsel for the petitioner.
Your lordship, I
Matter
have
is adjourned today. List after vacation.
petition.
list after ensuing some petition.
Lordship, I have one more prayer for listing of a matter, first matter. here.
Just a moment. 41. 41 lists the matter before any other bench without one of us. Give my name. You have a prayer for listing at what stage?
This is fresh matter, Your Lordship. We have just filed.
Give it.
My lordship, I beg to mention listing of one item, WPC number 1534/2019. Here the petitioner got bail in the year 2021, but still he was arrested in the May 2025, my lordship. And he was sent to detention camp. Now exactly we don't know where he is.
You filed an IA?
We will file an IA because one of his member is declared as Indian, my lordship, his sister.
No, no. Have you, for this incident, have you filed an IA?
We are going to file today, my lordship.
File it and then make a mention.
May it please your lordships. Your lordships, I beg to mention item number 27, lordship. Lordship, the matter came by way of an order, lordship, but sadly, lordship, the engaged counsel, he has fractured his legs, lordship. And as such, lordship, I'm praying for some accommodation in this matter, lordship.
Okay, list after ensuing summer vacation as prayed for by land counsel for the petitioner.
Highly obliged, lordship.
For motion, item 1.
My lord,
What is the best document we have to connect you to your projected parents?
my lord, Gambra's certificate is there. ma'am. At page 24-25.
You don't have any other document except for Gampura certificate.
My lord, voter list is there, voter list of 66. At page 14.
Which is your first voter list?
Yes, my lord.
Which one is your voter list? First
No, my
voter
lord,
list.
I do not have any voter list. My father, mother, 66, 70. My brother's name is there, my lord, in 1985. Again, brother in 1997. Along with brother's wife, my lord.
And you have no other official documents.
My lord.
There is no other official documents
Which one, my lord?
to show your presence in India. You have no other document except for your father's voter list.
Hmm. Father's voter list. So, my lord, my humble submission before your lordship, the judgment is of 2019. And I came before your lordship in 2020. By order dated 17/12/2020, LCR was called for, my lord, and thereafter also in 2024, twice the case were listed, but did not reach. But as on today also, my lord, that LCR has not come. Now,
No, LCR is there, very much there.
my lord,
LCR is very much there.
my lord, but in cause list. it is
LCR was
mentioned.
received in 2021.
My lord,
But we don't find
In that case,
anything,
my lord, may I pray before your lordship?
but we are not finding anything to,
My lord,
in your favor.
Pray-
This,
my lord, your lordship will, LCR is received, your lordship would be pleased to release the matter for admission. That's all right, my lord, but police is after.
no, we are,
Recently, there is a development. my
no,
lord.
we have seen this. We don't find anything in your favor in this record.
No, my lord, 1966 voter list, there's the linkage, and your lordship would be pleased to see that report of the SP, my lord, on the basis of which my case was started,
No,
That-
no, your
that is
case
a
was started on the
paper case.
basis of reference by ERO.
my lord. Now, your lordship will turn to page 28, 29. Twenty-eight, 29. Page
Yes.
28, my lord.
This is
Blood
the
name
ERO
of-
reference. The Superintendent of Police
Superintendent of
has
Police,
no
my
role
lord.
in it.
This is the report prepared by Superintendent of Police, my lord, see, Rule 9A. Rule 9A, my lord, it is of Illegal Migrants Determination Tribunal. Yeah, the Determination Act 1983, which is repealed. Anyhow, my lord, this form is used as on today. So. Now, my lord, my humble submission before your lordship. Name of the person Ashok Ali, and father's name is Ramzan. And entire decision of the learned tribunal, my lord, based on that, I am not son of Ramzan. A reference is made that I am son of Ramzan. Now it is said that I am not son of Ramzan. Then it is a serious contradiction, my lord, that with this report and finding of the learned tribunal,
There are not one, there are many judgments of this court
my lord.
where this issue has been settled.
So, my lord, my humble submission before your lordship at this stage, my lord. Your lordship, by first order, 17/12/2020, observe that the interim order will be considered after the LCR is received. my lord.
But you must show us some
Yes,
admissible
my
document.
lord. May
You
I
are showing
pray
us
that,
only
my lord,
the-
for short period, my lord, I may be granted interim bail, my lord.
No, no,
Okay,
we don't find merit in this writ petition, Mr. Sheikh.
my lord.
If it is only the voters list, then you do not prove anything.
The evidence is there, my lord. DW1, myself examined, my lord. Page 38, 39.
Yes.
38, 39. My lord, your lordship will turn to page 38. And here, examination through court, my lord, in the middle.
Yes.
What I shall state shall be truth. When did your father die? My father died during my childhood. Now, my lord, what is the relation with Amir Hussain? So, my lord, regarding Amir Hussain, my lord, Amir Hussain is my elder brother. Now, your lordship would be pleased to turn to 2021, page 2021, which substantiate my contention.
Page number?
My lord, first I refer to page 38, my lord.
Yes, 38 we have read.
Yeah.
Next
Now,
which
my
page?
lord, your lordship will turn to page 20. My brother's name is Amir Hussain. Amir Hussain, it is a voter list of 1997. Amir Hussain, Ramzan. So, my lord, I properly answered the question put by the tribunal, my lord, for me. That Amir Hussain is my brother, and Amir Hussain is my brother, that is reflected. And Amir Hussain's father is Ramzan.
Yes, Mr. Sharma.
My lord,
Yes, yes, Mr. Sheikh. You wanted to say something more?
my lord,
Yes.
your lordship would be pleased to see this exhibit E, Gambura certificate, my lord. Page 24-25. And Gambura was examined as DW 200 at page 40.
Yes.
Firaz Ali, my lord.
Yes.
Examination through court. What I shall state shall be truth. You are Gambura of whose village and since when you are working as Gambura? Since I am 1997, I have been working as Gambura of village number 1, Bagmarasar. Exhibit 1 is the certificate. Exhibit 1 is signature of survey officer. Exhibit 1-2 is my signature. How do you know second party of this case and since when? I know Ashok Ali, second party of this case since childhood. He is resident of village Bagmarasar. His father's name is Ramzan Ali Mondol. I have issued certificate. In this case, exhibit E is the said certificate. So, my lord, this certificate is rejected. Certificate exhibit E is rejected by the learned tribunal on the ground that state emblem was used. To that, my lord, my contention before your lordship, Gamura was appointed by the deputy commissioner under Assam Land and Revenue Regulation. So, my lord, he is working as a government employee, my lord. So using emblem, there may be some technicality on it. For this, my lord, this petitioner should not suffer, my lord. That is a technical point.
Okay. Yes, Mr. Sharma.
Lordship, first of all, Lordship will kindly see during filing of this writ petition, Lordship petitioner was aged about 48 years. If he is 48 years in the year of 2020, then he is entitled for his first voting right in the year of 1990. But Lordship, till today, Lordship, he is not able to produce any voter list, Lordship, to prove his existence, Lordship, in the territory of Assam. Not only voter list, there is not a single document apart from Gaubra certificate, Lordship, not a single document has been placed on behalf of the petitioner, Lordship. Then, Lordship, petitioner exhibited 1966, voter list 1970, then 1970 to 1997, there is a long gap, Lordship. Between this period, Lordship, what happened to his father, Lordship, that was not mentioned in the written statement, Lordship. And after that, also, Lordship, since 1997 to 2010, there is also a long gap, Lordship. So there is a lack of continuity, Lordship. And Lordship, and petitioner is relying Gaubra's certificate, Lordship. It bears, Lordship, state emblem, Lordship, for which this certificate is not admissible in evidence, Lordship, and it was discussed in the opinion, Lordship. And Lordship, Apart from although Gaubura has examined lordship in para 8, page 46 lordship, in this paragraph lordship, honorable tribunal lordship clearly discussed why it was rejected lordship. So lordship, there is no infirmity in the opinion passed by the learned tribunal lordship. So lordship, I think there is no merit lordship in this petition lordship. Not a single document has been placed by the petitioner lordship. Although he was entitled for first voting right in the year of 1990. Also, there is nothing to argue, I think, lordship.
Okay, we'll examine and pass on this.
Yes, lordship.
But, may I refer to my grounds for this? Grounds, my lord, at page 8. My lord, at page 10, my lord, my ground number 14, that the learned tribunal misinterpreted section 3 of the Indian Evidence Act and failed to read explanation added to the section. Para 13 of the judgment, my lord. This ground related to para 13 of the judgment. Para 13 at page 48.
Okay. What is,
My lord, OP had also submitted a self-serving show moto affidavit, which is marked as Exhibit F. But such affidavit is not included in evidence as per section 1. Section 1 will not come, my lord. Section 1 is another thing. Section 3 of the Evidence Act. May I read this Evidence Act, my lord, section 3? Let the learned tribunal refer to section 1, that is short title, etc. my lord. It will not come. 3 is interpretation clause, my lord. Facts means so and so, my lord. Lastly, and to place before your lordship the explanation. Whenever under provisions of law for the time being in force relating to civil procedure. It's a civil procedure, my lord, before the tribunal. Any court records an issue of fact, the fact to be asserted or denied in the answer to such issue is a facting issue. So, my lord, my humble submission before your lordship, I want to submit before your lordship that this explanation is not explanation of section 3 is not properly read when this para 13 is written by the learned tribunal. And next point, my lord, ground number 15. Learned tribunal failed in considering section 137 of the Indian Evidence Act, as well as provisions of order 19 of CPC.
Mr. Sheikh, you are fundamentally wrong when you are referring to the explanation under facts in issue
My lord.
of section 3 of the Evidence Act to read as if it's an explanation to the section. This is not an explanation to the section. It is merely an interpretation, or sorry, explanation to facts in issue. facts and issue appear only in the civil procedure code. It does not appear in the criminal procedure code. It does not appear in any other law except for CPC.
My
So
lord.
therefore, this explanation is to cover the CPC
Hmm.
foreign facts and issue.
Hmm.
It will be
No,
referable
my
to
lord,
order 14
My
of the
lord,
CPC.
Here, the proceeding is a civil proceeding, my lord. On it is civil proceeding.
But it's not a proceeding under CPC.
No, not at all. But thing is this, my lord. As per foreigners order, my lord, 1964, CPC is not totally ousted, my lord. In a particular point, my lord, where it is necessary CPC, it is said civil, it is said explanation, my lord, my humble submission before your lordship, relating to civil procedure. My lord, now you have a pause, my lord. It is a procedure. Some proceeding is going on in the tribunal. My humble submission before your lordship. It is not a criminal procedure. It is not a criminal proceeding. My humble submission before your lordship, it is a civil procedure case. Because, my lord, evidence taken, we used to give evidence by affidavit. That is also taken. And civil procedure is not as a whole, my lord, that the tribunal can take its own course for procedure, etc. That is also there. So my humble submission before your lordship, it is not a criminal proceeding. If it is not a criminal proceeding, my lord, then finding under para 13 is not proper. CPC as a whole will not apply. That's all I mean. But if your lordship allow me to read this section 141 of the CPC, we find, my lord, that certain proceeding is not a miscellaneous proceeding under CPC. Certain proceeding are not miscellaneous proceeding under CPC, which include writ petition under Article 226 of the Constitution. It will not come under miscellaneous proceeding. But it is not said that any proceeding under tribunal, before tribunal, will not be miscellaneous proceeding. Hereby, my lord, if we read this section 141, in that case, my humble submission will be before your lordship for consideration that it is not ousted from CPC.
No, I'll be too happy if you say that the CPC will apply. I'll be too happy out of
Not totally.
in the bench. I won't say about my sister, but yes, I would be very happy if I can interpret that CPC will apply.
No, my lord, my humble submission before your lordship, it is not totally ousted. We cannot say that no, CPC will not apply here. Then what procedure will be followed? Some procedure is to be followed. And we are giving always this affidavit in SIP by swearing in affidavit. What is that procedure? That procedure is CPC procedure.
Yes.
That is my submission, my lord, before your lordship. Now, your lordship, my ground number 15. The learned tribunal failed to consider section 137 of Indian Evidence Act as well as provision of order 19 of the CPC. It is a procedure followed in the tribunal for examination of SIP of the witnesses given in the form of affidavit. What I have submitted already, my lord. As such, the tribunal has committed wrong by not accepting evidence in SIP by affidavit. Section 137, my lord. May I have a look?
Yes.
137. examination in chief. What I want to submit before your lordship, that is that there is some form, that is examination in chief, cross-examination and re-examination. That is meaning thereby examination chief is a form to adduce evidence, but that part is not considered by the learned tribunal. That examination in chief affidavit we have, in affidavit we have we sworn in and filed affidavit, that part is not considered at all by the learned tribunal. So, my lord, that is my humble submission. And regarding this, my lord, voter list, my lord, that voter list certified copy I have given, my lord, that is to be considered by the tribunal. Whether it is only thing it is said that I could not link up. That is the finding. But whether this certificate relate to me or not, or my father's voter list or not, that is not denied. Your lordship will be pleased to see section 77, ground number 11. Proof of document by production of certified copies. My lord, before that, my lord, let us read section 76. Certified copies of public documents.
You don't have to read it. Just tell us your submission.
My lord,
You don't have to read the section, just
no,
tell us
my lord,
the,
not necessary, but your lordship would be pleased to see in para 11 of the judgment. My submission that has been, section 77 has been violated because exhibit A and B has been not accepted. So para 11, your lordship would be pleased to see of the judgment. Besides that, page 47, my lord, last paragraph, para 11. How my exhibit A and B, voter list of 66 and 1970 has been rejected, my lord. Besides that, without examine, it should be examining the original custodian of primary evidence to verify the contents. Verify the contents of entire exact copies of the voter list had no evidentiary value. It's a certified copy, my lord. I have produced, and as a threshold, it is said extract copies of voter list. It is not extract copy, my lord. It is a certified copy. Extract copy of voter list had no evidentiary value. It's not a correct finding, my lord. My humble submission before your lordship. No evidentiary value. Can it be said? It cannot. Now it is said, it is a settled position of law that mere production and making a document as exhibit, my lord, it is not a mere production and exhibit the document. It is a certified copy. Certified copy was issued by the authority empowered under relevant provision of law, my lord. So certified copy was issued. How that can be brushed aside like this? It's not proper finding, my lord. Para 11.
yes.
Now your lordship will see para 12, my lord. Has narrative of the OP suffers from multiple material omissions and contradiction rendering the entries of the voter list pertaining to his parents is an Indian citizen is not believable and trustworthy. So, my lord, my humble submission before your lordship, the voter list of 1966 and 70 certified copy has been brushed aside like anything. It's not believable. There is some contradiction. Maybe some contradiction may be there. And throughout my evidence and pleading, that is written statement, my lord, I am claiming that I am son of Ramzan Mandal. Name of Ramzan Mandal somewhere written as Ramdan, like this, my lord. There is some alphabetical variation. To that extent, my lord, I have given affidavit. And that affidavit is not accepted, my lord, and taking recourse to section 3 of the evidence. What I already read to you. There may be slight variation, my lord. In name, in age, my lord.
Okay.
My lord. And lastly, my lord, I am again repeating. My father name has been stored in Ramzan. In the reference itself, my lord.
Only
That we
statement,
have noted.
only statement, lordship.
My lord,
And
in that case, my lord, my humble submission before your lordship. If the authority say, your lordship will definitely consider. If the authority say, what is my father name? My father name is Ramzan. And the name of Ramzan, I have given voter list 66, that is rejected, 70 rejected. Gambura said that I am son of Ramzan, rejected. They said that I am son of Ramzan. On the other hand, tribunal say, no, you are not son of Ramzan. If I am not son of
No, it
Ramzan,
doesn't say you are not son of Ramzan. They say you are not able to
Yes.
link with the person whose name is
Ramzan.
Ramzan and whose name appears in the voter list of 1966.
Gambura is saying.
We
that-
have taken note of that.
Yes, my lord.
Yes, lordship.
Gambura saying, and what happened, my lord? I am throughout my case. It is the case of the authority that Ramzan is my father.
We have taken note of that.
Yes, my lord.
Lordship,
Obligers.
regarding voter list, lordship, I am referring para 14 of Aziz Mia's case, lordship.
Just note it and give it.
Yes,
The-
lordship.
In a slip of paper, please give it.
And lordship,
My lord,
I want to read few lines from up
Just-
to-
We are very short of time.
Yes,
Just
yes,
tell
lordship.
the,
My lord.
tell it in the written slip and give it
My
to
lord,
them.
just 2 minutes, my lord. My lord,
If you are referring to any citation, please give it to the court.
my lord, yes. Regarding this variation of
Whatever.
name,
Give it,
etc., my lord,
give it to the court.
I'll provide, my lord. Yes, obligers.
Item 2
So,
for motion.
And pass over the matter for time being.
It will go to Monday. We don't have time today. On the plan made by learned constitute with this one, make it Monday.
Item 3 with 4.
Lord, can you take up item number 4 first? I filed an additional affidavit by answering your lordship's query regarding the delay in filing the instant writ petition. When 2020 a writ petition was filed jointly by both the petitioners. Then what happened is a reference was received, a summon was received, my lord, by the wife, that is the petitioner in item number 3. Your lordship would find that particular summon at page 30 of the additional affidavit. A separate reference case have been drawn against her. Since she appeared and started contesting, both the petitioners decided.
Mr. Sharma, you please go through it and then respond. You have to respond to this. We take it up on Wednesday.
Yes, lordship.
There's a reference against your brother.
My lord,
He's your brother.
the reference has been decided. What I have annexed a separate judgment, your opinion, your lordship. A reference has been decided against my two brothers of the petitioner in item number 4, and they have been declared to be citizens.
That's why it's they are your brothers.
Yeah.
You go through it, just examine that
Yes.
additional affidavit. Both sides are represented in view of the stand taken in the additional affidavit filed in WPC 1954 of 2025. Sir G. Sharma, Annette Standing Counsel for the FT matters, shall examine the same and address the court on the next date of listing. Next para, list on Wednesday,
18/6.
18/6.
Oh, bless.
In the, in item number 3, list on 18 so and so along with item 4.
Lordship. In respect of item number 2, lordship, your lordship fix the matter on Monday, lordship, except Monday, any other day, lordship.
Wednesday?
Okay.
Oh, Mr. Sarkar, if you are there, you will take it up. Item 2.
Lordship, I am ready.
Item 2.
Okay, this is an ex parte order, lordship, page 16. And on the last occasions, lordship, on 35, your lordship heard the matter on length, lordship, and on that day, lordship, learned counsel, lordship, they took time to produce some documents, citations on last occasion. আগতে তো সময় দিছিলে বাবা আমাকে citations আসলে।
Lordship, I have, let it come on Wednesday, lordship. Wednesday.
The Attorney Standing Counsel for the FT matters shall peruse the records and address the court on the next date of listing. List on so and so. Please go through the record. If
Yes,
you
yes,
want,
Lord.
you can take it.
Yes, lord.
Item 5,
Yes, issue is solved.
Yesterday evening, he was taken to, he was taken to Guwahati. He's been taken to Guwahati today at 12 o'clock. I have been informed that he will be taken to Delhi and he'll be handed over to the Nigerian embassy.
Okay.
Let the matter come up on 18 or 19.
Okay, we'll take it up Friday then, next Friday. It is 2-0. All sides are represented. Next, Mr. D.K. Agarwal and counsel for the petitioner. Upon instructions, I submitted that as per his instructions, the petitioner is being transported from Guwahati to Delhi today for being produced before the competent authorities. Full stop. Accordingly, awaiting further developments in the matter. Next list on. Oh, no, same line. Waiting development in the matter. List on 26/2025.
Much obliged.
This is record the presence of Mr. Adhikari, Mr. Sharma, additional senior government.
I appear for 1 and 3.
Item 7.
Yes.
I'm aggrieved by order dated 19/3/2025, that is at page 80. Also, on the last occasion, Lordship has directed me to find out whether any document is there to prove his thumb impression. Lordship, I have just got a copy of this. I could not file it by affidavit because it has been provided to me today morning. It is a certificate for registration, Lordship. Under Section 5 of Citizenship Act. Where his thumb impression is there. Want to prove the contents of the annexer 5 affidavit at page 67. Is an affidavit shown by the father of the petitioner. It appears to be of Sambhu Mal, it is the father of the petitioner.
To my limited understanding from this, the thumb impression will not be able to be taken up. No impression of this can be gathered. Just this impression is too weak for any analysis. Have you taken what do you call private advice from any forensic expert?
No. I would, but no.
No. I don't think the impression from this can be. It will not come. Take out your mobile and then enlarge it and see, because I'm not carrying a mobile. Can you enlarge and find any semblance of any
Yes, Lordship.
Counters are coming.
Otherwise, it is coming, Lordship, but
If it is coming, then it can be taken up. If he has a document.
I have got the original copy of that affidavit also, that can be compared also.
You can't have, you can't have a opinion on the basis of a single document.
No, what I am submitting is.
It
we
must
can
be a
compare with
compared,
this.
it must be a document compared with someone.
This one,
Signature is admitted.
This one may be compared with the affidavit also. Where my thumb impression, original copy of the affidavit is with my name.
It-
medical practitioner can say, Lordship. Thank you. Lordship,
They are expert, give me.
Lordship, things speed. Doctors may be called for from the
This for
Pardon me?
forensic.
Lordship.
No, this for forensic.
And doctors have some better idea regarding this. So Lordship, if Lordship thinks speed, Lordship may call for.
No, we are in a writ petition, we are not doing anything
Yes,
like that.
Yes, Lordship, yes.
He has filed an application before the tribunal has rejected it. We are just examining that order.
Yes,
We are trying to satisfy ourselves that
Yes.
with this, whether the thumb impression can be extracted and examined.
Yeah.
And compared with some other signature.
yes, Lordship. এইখন document. Genuine. আমি impression to sabot. Forensic or traditional, it insurance. Order for the
No, এটা thumb impression তো proof করবো না। Affidavit মানে একজন মানুষ হয় না।
Otherwise, there is no leak. Next find them what I say, in Nigeria. Nigeria case. Yeah. That is it.
চাব কাৰণে পৃথিৱীতে যিটো আছে সেইগুলো একেজন মানুহ হয় ন ফৰেন্সিকৰ কথা কৈ আছে সেইটো কাৰণে এখন বেলেগ একো নাই। Lordship, give me a chance to prove this.
We will interfere with this order. Let it go to the tribunal, let the affidavit be examined in whatever manner they deem fit. We are not giving any opinion how to do it.
Yes. Oh,
Because the ground in which this order was rejected is not tenable. Yes, Mr. Chairman. Heard. Mr. M. Mohantal and counsel for the petitioner. All the respondents are there, Ms. P. Barwa. Next one, the case of the petitioner is that suspecting the nationality of the petitioner, a reference was made by the Superintendent of Police within bracket border, bracket close, Kamrup Metro, Guwahati, which was registered as D full stop, V full stop, case number 1633/2019 bracket P/C number 5274/1998 bracket closed, comma, which is pending before the learned member, comma, Foreigners Tribunal number 5, comma, Kamrup Metro, Guwahati. Next one. In order to establish his case, public defense, comma, the petitioner had produced a copy of, has produced an affidavit purportedly sworn by his projected father on 19/10/1985, which was exhibited as Exhibit 5 in the said proceeding. Next one. But what is this prayer? I couldn't understand. Page 72. What is the prayer? I will need a English to English translation. What do you mean by it? What is the message you want to convey through it?
The corroboration of evidence, I already has additional evidence and affidavit to ascertain fact of genuineness of document. Handwritten is there, it's page 75. Handwritten is also there, page 75.
No, we understand, but what is the meaning you want? What is the prayer in your
To prove the
before the?
genuineness of the affidavit,
Huh?
to prove the genuineness of the affidavit sworn by the father of the petitioner.
No, but tribunal will not prove it.
They have not allowed me to prove.
That's not even your prayer.
Allowed to corroborate for evidence file.
Corroboration of evidence.
Language is not said, but my prayer is to prove the document.
No, we don't know. You see, you file an evidence. You can't have evidence to corroborate an evidence.
That is, the language is wrong.
No, but still, what do you want?
I want to prove the document. That is the affidavit sworn by my father to prove the linkage with my father regarding the surname. That is. My
No,
father
Mr. Mahanta, I hope I am able to communicate with you.
Yes.
You see, you file a document and that is the manner to prove a document. Under section 61, every document has to be put in original. Let be 63. So you are producing it. So then what is the scope of a prayer? Court is not disallowing you to do it.
Yes, it's.
You have already filed it as Exhibit 5.
Yes.
Exhibit F.
Exhibit F. But since it is 40 years old, the court has said that I cannot be allowed, permitted to prove the document, prove the contents of the affidavit.
No. Some difficulty in understanding. You see, now let me say that today is a good day and Mr. Sharma wants to file an affidavit. saying that he is the President of India.
Yes.
Correct. Today is a good day. And he wants to file an affidavit that he is the President of India. Now he files that document before the court. Now, how will he prove the contents of that affidavit? Now Mr. Sharma cannot bring Mr. Payang as witness and say that now he will prove the contents of this affidavit that I am the President of India. So actually, when you say that you want a corroborative proof, what is the, I'm trying to understand what do you actually want from the court?
See, my thing is that my father had sworn that affidavit and he is expired. So father of the petitioner is expired also.
I
That's
understand.
why I have no other option to prove this document, the contents of the document regarding the change of surname, only through the persons who have,
No, under section 32 of the Evidence Act, any person who is dead, 32 1, you can still exhibit the document and prove it. Somebody who knows the document can always prove it. Section 32 does not prevent you from doing it if somebody is dead and cannot be found. I am wrong by one section, 32 2.
Yes.
You made in course of business. So he makes that. Okay, whatever is there in that prayer, forget it. What is the prayer you are now making? Tell us, what is the prayer you are now making before us?
may allow me to prove the harm impression of the father of the petitioner
You want to prove a thumb impression.
in the original this
Okay.
affidavit.
But that, Mr. Mahanto, we merely say that you will make an appropriate prayer before the tribunal, let the tribunal take a call. We are not saying what.
That will solve.
Uh,
My prayer is that if there is a documents, if they want to prove the documents, let them prove, man. They want to prove the documents by
No,
whatever
no,
means.
you see, there is not one problem. When this question is being put and we are examining that, many questions will arise.
Yes.
You see, number one, we are in a statutory jurisdiction.
Yeah.
We know our limitations.
Yes.
We can't do something which has not been prayed for. So the prayer is to give a corroboration. Corroborative evidence can't be led.
That's what matters.
That's why I give an example. It was a horrible example, but if I dramatize, you understand well. You understand it more better. So that's why I dramatize. That the effect is that how is to be proved is for him to decide.
That's why, man. Let them
So
prove.
let
If
him
they are-
file an
if they are
appropriate
proven,
application.
yes,
This order will not be a bar for him to present an appropriate application.
Yes, it is their duty to how to prove, man. We don't know.
We don't know. Because it is this word, when we are writing this order, the word corroborative, when I read, it becomes a very difficult task. I would have understood something else, but word use is corroborative. For affidavit, you can't have a corroborative evidence.
Actually, an error.
That's the difficulty.
It's an error also.
Unless you convince me, I may be wrong,
No, 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 sir.
but
It's an error also. On our part.
what was the last? Exhibit F. Full stop. Uh, What is the date when this petition was filed?
19-3.
19/3, 2025.
Yes, ma'am.
On 19/3/2025, the petitioner had filed a petition to enable him to prove the said affidavit within bracket Exhibit F. However, the said prayer was rejected by the learned tribunal while order dated 19/3/2025 on the ground that the affidavit was sworn more than 40 years back and the record of the register of the executed affidavit, in the view of the learned tribunal, was not maintained at that period. Next paragraph. Any interference with the said order dated 19/3/2025 is opposed by the learned standing counsel for the FT matters. Next para. Having noted that the petitioner did not make a prayer before the learned tribunal to call for the record of the register of executed affidavits, the ground on which the said prayer was rejected is not found tenable. Next para. Accordingly, the court is inclined to provide that the said order dated 19/3/2025 passed by the learned member, Foreigners Tribunal number 5th, Kamru Metro Guwahati, shall not be a bar for the petitioner to move an appropriate application in respect of Exhibit 5 affidavit in a manner which the petitioner may be so advised. Full stop. With the liberty as indicated above, this writ petition stands disposed of at the motion stage without issuance of notice on the respondents.
Item 8.
Now you want to know why it should, why this could have been rejected otherwise by the trial court. You have Evidence Act with you. Now take this. That's why this one word. C32, ABCD. Just read the headline. 32A, what is that?
32(1). When it relates to cause of death
So this affidavit is not for cause of death. Con. Number 2.
or is made in course of business.
You see in that business, the affidavit of, the nature of affidavit is not covered.
when the statement was made by such person in the ordinary course of business, and in particular when it consists of any entry or memorandum made by him in books kept in the ordinary course of business, or in discharge of his professional duty, or an
Correct, so
acknowledgement
it is not covered. Now three,
or against interest of maker. When the
against
statement
the interest of maker is not there. So none of the clauses there, 6 or 7, whatever is there,
or
it covers none. Correct. This petition deserved to be dismissed. But you want to prove some document of your father of 40 years back, you allowed it. But the nature of prayer made deserves dismissal of the writ petition. Yes, next.
Item 8.
Yes,
We are challenging the judgment and order dated 5/4/2025, passed by the honorable member foreigners.
which page is the opinion?
Lordship, page 38.
Page
38.
38. You'll have to shout. You have to make us hear your voice. 38,
38.
5/4/25. Okay. Mr. Pang, give her protection. Your name?
A.M. Hussain.
A.N. Hussain. Okay, heard Miss A.N. Hussain, then transfer the petitioner. All the respondents are there, Ms. P. Barwa. Page 38, opinion dated 5/4/2025. Passed by so-and-so in so-and-so. Declaring the petitioner to be a foreigner post 25/3/1971 stream. Notice, extra copies within 2 days, call for the records. Prayer for bail is opposed by the standing counsel for the FT matters, considering the projection made in this petition. 10 days time to take bail of ₹5,000 to the satisfaction of
No, Bongaigaon.
Bongaigaon.
SP Border Bongaigaon.
Item 9.
There is no representation from the petitioner. Power answers justice the matter stands adjourned today. All the respondents are represented. List out after a week. Item 10.
May I please,
Yes,
My
Mr.
lord,
Magat.
Lordship will find my lord, the impugned my lord, opinion at page 107, my lord.
107. Okay, 29/4/25.
Yes.
Okay. Page 107, Mr. L.U. Mandal. (29/4/2025). Notice bail out ₹5,000 to the satisfaction of
SP border. SP border,
SP Border
SP border Borpota.
Borpeta. Okay.
Yes,
Item 10.
developed.
Item 11.
Page 41, my lord, opinion, 8/7/24, my lord.
Page number
Yeah, 41.
Okay. Forty-one. Mr. A.W. Ahmed, Learned Counsel for the petitioner. On the response of Mr. Islam on behalf of AILE. 8/7/2022, passed by so and so. Notice extra copies. Prayer for bail is opposed by the understanding counsel for the FT matters. 10 days time to take bail to the out of rupees 5,000 to the satisfaction of
Barpeta, ma'am.
SP Border Barpeta. Okay.
Grateful, ma'am.
Item 12.
My lord, the here matter was decided on contest into an opinion at page 89.
Five nine
My lord, 89.
89. Okay. Mr. A.R. Sigdat, Learned Counsel for the petitioner. Respondents of them is P. Barwa. Opinion dated 22/4/2025. Passed by so and so. Bail of rupees 5,000. 10 days time to take bail of rupees 5,000 to the satisfaction of
SPB Dhubri.
SP Border Dhubri.
Biplab.
13.
Twenty-five, ma'am.
Page number
25. 22/4/22, ma'am, order.
This is 22.
My lord,
Then you have to wait for some time for bail.
my lord.
Mr. A.W. Ahmed, Learned Counsel for the petitioner. The respondents are there, Mr. Islam on behalf of AILE. Opinion dated page 25, dated 22/4/2022. Passed by so and so in so and so. The petitioner to be of foreigner post 25/3/1971 stream. Notice returnable on
18/7.
14/7/2023. Extra copies of the 2 days. Prayer for bail shall be considered on receipt of records list on so and so. Which document is exhibit A,
My lord, exhibit A is,
page 47?
yes, my lord, transfer certificate. Transfer page 47, my lord. The issuing authority deposed as DW2, my lord.
Yes,
May I be pleased, Your Lordship?
yes.
Well, so yesterday, the
Mr. Mishra, we're just starting with a lighter note.
uh,
Always we start the hearing with, may it please your lordship, but is hearing so pleasing? Is it pleasant? Just started with a lighter note.
yes, yes. On lighter note, let me tell Your Lordship one story. Your Lordship will know Jalre Angami, who became judge of the High Court.
Yes, yes.
Justice Jalre Angami. He was my colleague. He was assistant public prosecutor when I joined the bar. And we were arguing a matter before Additional Deputy Commissioner I.K. Chankija. While we were arguing, he was sleeping. So I told Jalre, stop it, he's sleeping. Then suddenly we said, we have completed. Then he got up and he said, thank you, gentlemen. Very nice to hear you. Then he opened his drawer and took out the bail order. Here is my order. So you always remember that.
You should have given this idea before we started hearing.
Not in such a long case. It's not possible. That was a bail order and he had been done it. Anyway, coming, my lord, because the time is less and others also have to join, I'll cut short my argument. My lord, yesterday, the last submission that I made was on confirmation by placing section 17 of the APS rules 1966, wherein, my lord, I submitted before your lordship that no express order of confirmation is contemplated or provided under section 17 of the APS rules 1966. For confirmation, there are three requirements. One is that he should complete his probation period to the satisfaction of the governor. And the second was he should complete the training and pass departmental examination. And the C is any other reason he is entitled to be confirmed. Now, these two, the last two, B and C, there is a power vested in the governor to relax. So my submission is that once it is provided by in governor's order that I have completed my period of probation, then that's the end of the matter. The other things can be dispensed with. And that is how I am submitting before your lordship that there will be deemed confirmation. there will be deemed confirmation. Now I come to the last point. After that, I'll go to the decisions that has been cited by the other side. My learned friend, Mr. Kohli, submitted that we have handed over sealed cover procedure, which is approved, and then he did not cite any decision, but he has said that so many decisions are there where the court has accepted the sealed cover procedure. Now, first of all, what did he hand over according to his own affidavit in opposition? My lord will kindly take up item number 65, Savira Imran's paper book. Savira Imran's paper book.
Appeal memo.
My lord.
Appeal memo.
Yes.
196.
Yeah.
Serial number 65, readable 196.
196, yes. Your lordship may turn to page 159. Paragraph 41.
Yes.
I'll place 41, it's a small paragraph. The Assam police is carrying out the detailed and thorough investigation into the colossal recruitment fraud. During the ongoing investigation, the statement of various accused persons, writ petitioners, including the present writ petitioner herein, who have stated in the investigation that they have paid bribe, have been placed before this court in a sealed cover of its for its consideration. So diary was placed. Now, what was contained in the diary that we don't know, except what they say, that it was a statement under 161. My lord, if you recall Amarbir Singh, there the statement under 164 was given in respect of some of the candidates. Because 164 can be relied upon, but insofar as 161 is concerned, there is an embargo contained under 162, the manner in which this will be relied upon. And there is, my lord, if I have understood correctly, there is an express embargo that it cannot be relied upon in any other proceedings except what is mentioned. (162), if your lordship can come to. Your lordship will kindly take up criminal procedure code. So that time it was applicable. Lordship got me?
Yes,
162.
yes.
Statements to police not to be signed. Use of a statement in evidence. No statement made by any person to a police officer in course of an investigation under this chapter shall, if reduced in writing, be signed by the person making it, nor shall any such a statement or record thereof, whether in police diary or otherwise, or any part of such a statement or record, be used for any purpose. Lordship will see there is clear embargo, save as herein provided at any inquiry or trial in respect of any offense under investigation at the time when such a statement was made. Provided that when any witness is called for by the prosecution in such inquiry or trial, whose statement has been reduced in writing as aforesaid, any part of his statement, if duly proved, may be used by the accused and with the permission of the court by the prosecution to contradict such witnesses. Rest we are not concerned. But my lord, there is a clear embargo that it cannot be used in any other proceeding save and except provided under 162. They are using here. Now we don't know, my lord. 172, if your lordship will turn for a second, my lord. Section 172 of the CRPC.
Yes.
1 capital B, if your lordship will kindly see. The diary referred to in subsection 1 shall be a volume and duly paginated. Now I am told, my lord, that these diaries were not paginated even at the time of trial when it was handed over. It was all type sheets. This is what we could not produce it, but this is what it is. So what I'm trying to say is, my lord, giving diary in a seal cover, not diary, the statement of witnesses under 161 in a seal cover, and then letting and making a request to the honorable single judge to consider it, that itself is wrong and should not have been considered at all. And my lord, I may say that the era of handing over sealed copies of any document to the court is gone by. Because there is a judgment by Justice Chandrachud, my lord, the then Chief Justice of India. Your lordship will remember. He said, stop this. No seal cover. That will not be accepted. That decision, your lordship, is separately I will give. It is 2023 13 SCC. 2023 13 SCC. Page 401. The relevant portion I have.
Please give the citation again. Name of the parties?
Madhyamam Broadcasting. Madhyamam Broadcasting Limited versus Union of India and others. Madhyamam. 2023 13 SCC, page 401. The relevant paragraph is 195.2.7. Your lordship got me.
Yes.
I'm placing it. The court assess the validity of public interest immunity claim which address the same harm as the sealed cover procedure based on structured proportionality standard. The power of the court to secure material in sealed cover when contradistinguished with the scope of assessment of public interest immunity claims is rather unguided and ad hoc. the standard of review that is used by the court in public interest immunity claim and the lack of such standard in seal covered proceeding to protect procedural safeguards indicates that public interest immunity claims constitute less restrictive means. Additionally, while public interest immunity claims conceivably impact on the principles of natural justice, seal cover proceedings infringes the principles of natural justice and open justice. It's a completely, my lord, rejected. Now, my lord, I will come to Pallavi's matter because everything is covered except that admittedly she was on probation. If your lordship will take up item number 2044.
44, item 44.
44.
You take it 98.
98.
Yes.
98.
98 of 2020.
Yes. Now, there will be no need of paper book, my lord. I can say that all the arguments that I have made in item number 65 will cover item number 44, except that she continued to be a probationer. She had not completed 2 years and she was a probationer.
Yes.
But not, as we have said, that the order was by way of punishment. No opportunity, no inquiry, and there were allegations that we entered our service by colossal fraud. There was loss of public interest, trust, and a and that, my lord, it was not reasonable, practicable to hold the inquiry under 311. That will cover this case. But one thing that I want to point out, your lordship will remember I placed some Singh case in my earlier argument when I began. That your lordship will find at page 46 of compilation 2. Paragraph 6, page 46. If your lordship remembers, I will not cite, but
No, please say it because very difficult to immediately
Yeah.
recollect actually was argued.
Your Lordship will take up compilation number 2 at page 46,
Yes.
paragraph 62. I'm sorry, my Lord, 62 and 63. The position of a probationer was considered by this court in Purushottam Lal Dhingra versus Union of India. Chief Justice Das, speaking for the court, said that where a person is appointed to a permanent post in the government service on probation, the termination of his service during or at the end of the period of probation will not ordinarily and by itself be punishment, because the government servant so appointed has no right to continue to hold such posts any more than the servant employed on probation by the private employer is entitled to do so. Such termination does not operate as forfeiture of any right of a servant to the post, for he has no right. Obviously, such a termination cannot be a dismissal or removal or reduction in rank by way of punishment. There are, however, two important observations of Chief Justice Das in Dhingra's case. One is that if a right exists under a contract or service rules to terminate the service, the motive operating on the minds of the government is wholly irrelevant. The other is that if the termination of service is thought to be founded on misconduct or negligence, efficiency or other disqualification, then it is a punishment and violative of Article 311(1)(11) of the Constitution. The reasonings why motive is said to be irrelevant is that it inheres in the state of mind which is not discernible. On the other hand, termination founded on misconduct is objective and it's manifest. No abstract proposition can be laid down that where services of a probationer are terminated without saying anything more in the order of termination that the services are terminated, it can never amount to punishment in facts and circumstances of the case. If the probationer is discharged on the ground of misconduct or inefficiency or similar reason without proper inquiry, without his getting a reasonable inquiry to show cause against the discharge, it may in a given case amounts to removal from service within the meaning of Article 311(2) of the Constitution. Now, this judgment in Samsher Singh case, the Constitution Bench decision, has been followed recently by the Supreme Court in Abhay Jain. Abhay Jain versus High Court of Judicature for Rajasthan and others. The citation is 2022.
Yes.
Well, the citation is 2022.
We have got it.
Yes. Well, I'll place paragraph 50 and 51 just to show what was followed here. And then the ultimate paragraph will be 52. In paragraph 50, The Honorable Supreme Court has referred to Gopi Kishore Prasad Singh. This is AIR 1960s Supreme Court 689, which in turn followed Dhingra's case. And at page 51, paragraph 51, sorry, Samsher Singh is extensively quoted. Having quoted, my lord, having relied on Dhingra and Samsher Singh's case for this proposition, whether probationer will be entitled to protection under Article 311 if he is discharged on misconduct. 52 I am placing. The present case of the appellant is squarely covered by the aforementioned Constitution Bench judgments of this court. Since the government had on inquiry come to the conclusion, rightly or wrongly, that the appellant was unsuitable for the post he held on probation, this was clearly by way of punishment. Hence, the appellant would be entitled to protection under Article 311(2) of the Constitution. Moreover, in the facts and circumstances of the present case, the substance of termination order reveals that discharge was by way of punishment. Hence, the question whether the action of non-confirmation of the appellant is in accordance with Rule 45 and 46 of RJS rule is answered in negative. Now, if your lordship,
Yes.
if your lordships remember, I had placed, my lord, two decisions. One was Gujarat case. One was Gujarat case where the judgment was by Justice Krishna Iyer, my lord. Gujarat case, the citation was 1980, volume 2, SCC 593.
Gujarat Steels.
Gujarat Steel Tubes.
Gujarat Steel and Steel Tubes Limited.
What is the citation, Mr. Mishra?
It is 1980, volume 2, SCC 593. It is at page 39 of compilation 2.
Yes.
Your lordship will recall I placed before your lordship that if there is live nexus between the misconduct and the order of termination, then the termination is by way of dismissal. This your lordship will get at paragraph 53,
Yes.
page 41 of the compilation 2.
Yes.
Just 3 lines, your lordship will remember. They are cited earlier also. At page 41, paragraph 54. The last 3 lines. Lordship got it?
Live nexus between it and the termination of service.
Yeah, given an alleged misconduct and a live nexus between it. 53, last 3 lines. And the termination of service is conclusion is dismissed. Even if full benefits as on simple termination are given and non-injurious termination is issued. Now I had shown your lordship that they have terminated the service and in the termination order, it is written under suspension. The moment the appellant goes and seeking other job, they will say, place the suspension order. Once the suspension order is there, placed before the new employer, he will say, oh, you were arrested. You were placed under suspension. So they tried to hide it, but they couldn't. And otherwise also your lordships are aware. The form of the order does not matter. It is the substance, and that could be found out. In many cases, the court have lifted the veil to find out whether the termination is in fact based on the misconduct or the termination is stigmatic. Now that word is mentioned in both the cases. The other case that I cited was Dipti Prakash Banerjee's case.
Yes.
Dipti Prakash Banerjee, the citation is 99-3 SCC page 60. 60, my lord. My lord, here also the discharge order was innocuous, but there was a reference of 3 letters. And the Supreme Court says the moment these 3 letters are asked to be produced by the new employer, everything will be open. That she has been discharged because of these allegations. Just to refresh, if your lordship will turn to compilation 2 at page 63, or if no need, then your lordship will tell me. Page 63, relevant will be at page 75.
Yes, we remember that. That
Yes.
is, we remember that.
Yes. Now, my lord, I'll come to the decisions that has been relied upon by the state. I'll say one line, your lordship may. The first decision is Shyama Pardhi, cited by Mr. Kohli. State of MP versus Shyama Pardhi. My lord, here the facts is quite different. And it was an admitted fact that the respondents who have been discharged did not possess prerequisite qualification, that is 10+2 in physics, chemistry, and biology as subject. How this will apply with admitted facts. Even if a show cause notice is given, the facts cannot be changed. So this is Shyama Pardhi case, 1996, 7 SCC, page 118. And this particular facts which I am narrating before your lordship is given in paragraph 5. Now I come to O Chakradhar, which was relied upon. This your lordship will get at page a compilation 111, the original compilation. This was a case of cancellation of the entire examination. And my lord, the appointment was for the purpose of to the post of junior clerk cum typist. And what was found by the tribunal is that typing examination was not taken at all. And still notices were issued. This hasn't been stated before your lordship. Your lordship will kindly, I'll just show that portion where notices were issued to them at page 113. Is quoted by the tribunal, and same is quoted here by the Honorable Supreme Court. 113, paragraph 3.
Yes.
My lord, it is, I'm reading the quoted portion at paragraph 3. Now it has come to the notice of the Railway Board that RRB Bangalore has not subjected the candidate to typing test, and he was appointed as junior cum typist, which was essential requirement, besides there being certain serious irregularities in conduct of examination. The Railway Board, after considering the matter totally and taking into account the report of CBI and a serious nature of irregularity in conduct of selection, has decided to cancel the entire panel to terminate the services of all candidates appointed on South Central Railway. Your Lordship will kindly mark it by giving a notice as per rules. The notice was given and it is quoted by the tribunal, relied on by the Honorable Supreme Court.
Yes.
Then, my lord, the next decision which was relied was Ashok Sonkar. Ashok Sonkar, your Lordship will write it is in the State Compilation Part 2.
But in this O Chakradhar,
Yes.
which you're referring, we just refer to the part which is after that.
Yes.
You had read this quoted part.
Yes.
If you come to page 114, Placitum A,
Yes.
they've decided
Yes.
to cancel the entire panel and to
Yes.
terminate the services of all the candidates appointed on South Central Railway by giving
Railway.
notice as per rules. But
Yes.
next part,
Yes.
the next part is
My lord.
from the end of the first line, the respondent preferred a petition before the Central Administrative Tribunal challenging the order of termination amongst others on the ground that the respondent was not responsible for any kind of irregularity. And in case it was committed by the Railway Recruitment Board, he could not have been responsible for it and it could not have so and so. The other ground, after two lines,
Yes.
the other ground of challenge is that proper show cause notice should have been individually issued to each selectee. So here also this individual show cause notices were not issued. That means Department of Proceedings was
No,
not.
that was, my lord, that was because it was not an individual fault. It was a collective fault. As I have said, in case of mass cheating or cancellation of the entire examination, yes, notices are not required to be given. And the other decisions also have shown. Because when the entire examination is cancelled, even if individual notices are given, it's not going to make any difference. But it appears that some notices were given here. Another thing is, your Lordship, remember, here in this case, Miller, the examination was conducted by the Railway Board. They did not conduct typing tests. So therefore, he says it is their fault, not our fault. But fact remains that you got selected without appearing in typing test, and it was a post where typing was necessary. Even then, some notices were given. But proper show cause, yes, not required to be given because it was case of the entire selection was annulled and everybody was terminated.
This your lordship will also find that paragraph 8, my lords, of Chakradhar and para 12.
I have placed paragraph 12. That 12 is that notice is required to be given. And the mischief is all pervasive. That's what I'm saying in short. I have placed this, my lord. If your lordship will see my argument initial, these things I have placed. Now, my lord, your lordship will come to Ashok Sonkar. I'm distinguishing it, my lord. It is 2007 4 SCC, page 54. It's in the state compilation, part 2. In paragraph 16, it is clearly mentioned that it's an admitted position that the appellant did not hold requisite qualification. Paragraph 16. I'll just read it out. Your lordship, permit me. Paragraph 16, I'm placing 2 lines. Indisputably, the appellant herein did not hold requisite qualification as on the said cutoff date. He was therefore not eligible, therefore. So this case, how it will be relevant, I'll leave it to your lordship. Then the next case is Dhirjo Kumar Sen Gupta. Singer, sorry. Dhirjo Kumar Singer. 2009, 13 SCC, page 600. Here again, my lord, the facts of the cases are entirely different. An application for compassionate appointment was filed before Joint Director, who rejected it. Thereafter, somehow the Deputy Director issued the appointment order without any succession certificate. The Deputy Director is a subordinate authority. When the Joint Director has rejected the application for compensate appointment, there was a question of subordinate officer appointing him. In that context, the Honorable Supreme Court said that no compensate appointment could be made in absence of legal succession. So that is the case. There is yet another case.
Yes.
Of Sachin Kumar, 2021 4 SCC 631. State compilation part 2. 2021 4 SCC 631.
Yes.
The proposition put forth by my learned friend Mr. Kohli was the police can segregate tented and non-tented candidates. My lord, here in paragraph 59, if your lordship will see, paragraph 59, committee was formed. The first thing they did was form a committee, which your lordship will get at page 57. Paragraph 57, page 669 of the SCC that I have.
Yes.
7, the committee was constituted, and in 59, it is mentioned that committee might not entertain representation from the candidates. Just 2 lines 15. The committee had representation before it from candidates as well. Thereafter, FIR, etc. were filed, but basically it was by the committee, and they gave their findings. Then, my lord, the next is Devendra Sharma, 2020 15 SCC, page 466.
Yes.
My lord, here the appointment was not to a sanctioned post. This you will get in paragraph 3 of the judgment. And in paragraph 12, your lordship will see there were only 2,250 sanctioned posts. Only 2,250 sanctioned posts, against which the appointments were made to 6,000 posts in paragraph 12 of the decision. Then, my lord, Delhi High Court case, which was relied upon.
This case I remember because of my comment that Manoran committee, yeah, Assam also had this. So that's how I remember it.
Yes, my lord. Yes, my lord.
Yeah.
Now, my lord, this case, the present one, the Delhi case, this is Naresh Kumar versus Government of NCT Delhi. My lord, this is a case. This is a case where it was an driver's appointment. The drivers were supposed to file an affidavit saying that they are not involved in any criminal case. And that was done by the present person. Paragraph 7, I'll just place it slowly, because we thought it will come from there, but it'll take time. I'll just read it slowly. Paragraph 7. That's the crux.
Yes.
I'll read it slowly, my lord. The respondent, Delhi Transport Corporation, has filed a counter reply opposing the OA. It is stated by the respondent, Delhi Transport Corporation, that in the attested form, petitioner specifically mentioned no criminal case was pending against him and that he was not involved in any criminal case. During verification of his character and incident, it was revealed that the petitioner was involved in criminal case, FIR number so-and-so, dated so-and-so.
Yes.
Now, the defense against this was that I was appointed 2 months earlier than this. Obviously, that had to be rejected because of the further finding that your lordship will see at paragraph 10. In paragraph 10, I'll just place it slowly. It is further contended that during verification, it was found that there was another criminal case, FIR number 21 of 2005, much before his appointment, registered under 307, 328, 23 and 34 in the year 2005, and the petitioner had not mentioned this in his application form. Now, even if a notice is given, these facts are not going to be changed. So therefore, my lord, the decisions that I have cited, that was cited, my lord, by the learned counsel for the state were not relevant, my lord, for the purpose. Now, there are other, my lord, 6, 7 decisions, but I will only say that my lord, there is one decision which I will say, rest I will leave it to honor, my learned friend. My lord, the decision cited was Union of India versus Bihari Lal.
He's denying. He's not received the briefing. He denied to carry on.
I just want to, my lord, save time, because if I continue, the others will curse me. Union of India versus Bihari Lal, this is important because this is 2 judges bench decision. 1997 4 SCC 385.
Name of the parties?
Union of India versus Bihari Lal.
Yes.
1997 4 SCC 385.
Yes.
This has been relied upon, and in his case, in his termination order, under suspension was mentioned in this case. And therefore, a great amount of stress was placed on this, that the suspension was mentioned and that has been upheld. In paragraph 4, it is, my lord, the word under suspension is given. And then the lordship says it's nothing. Unfortunately, my lord, Gujarat Steel Tube was not placed before this court. That Justice Krishna Iyer's judgment, where it says that live nexus between the misconduct and the discharge order would only be dismissal from service, and it will not be an order simpliciter. And it was followed in Dipti Prakash case. Now, Gujarat Steel is by 3 judges, my lord. Gujarat Steel is by 3 judges, Justice V.R. Krishna Iyer, Justice D.A. Desai, and A.D. Khoshal. The 2 judges bench, his judgment will be, my lord, is against the judgment of this Gujarat Steel. It's in the teeth of Gujarat Steel. And also, my lord, Dipti Prakash, which is 99-3. So this judgment is of 1997, but neither 1980 decision in Gujarat Steel was placed, nor the Dipti Prakash Banerjee was placed before this. Then, my lord, the other decision which was placed was from Guwahati Law report, from Guwahati High Court. State of Tripura, 2007 3 SCC. My lord, this is State of Tripura and others versus Krishnakant Devo Burman. Burma. 2007 3 GLR 55. My lord, this is a case where unauthorized absence during the probation period while undergoing training and in an admitted position. And where he has admitted, he has filed an appeal before the Director General of Police, where he has admitted, and just place that. I'm placing from paragraph 8, the relevant portion, just below placitum D.
This was admitted in a representation before?
Before the DGP.
Or the DG.
I just place it. 4 lines. However, he remained absent from training unauthorizedly for a period of 6/4/1994 to 29/6/1994. Thereafter, he reported for duty on 3/6/1994 and again remained unauthorizedly absent from 1/7/1994 to 4/7/1994. Annexure C appeal dated 30th/8/1994 addressed to the Director General of Police, Government of Tripura, which has been annexed to the writ petition. The petitioner himself has admitted about such unauthorized absence. What difference it would have made if a notice was given to him? He couldn't have changed the fact. One, I will not take your lordships through this, but one decision was placed, which I find, my lord, that it is not what was argued before your lordship. This is Khatri and others versus State of Bihar. 1981, 2 SCC 493. 493.
Yes.
Here the case diary was given, not 161 statement. So that is a distinguishing feature.
Please.
Because in our case, it is case diary which was given containing the alleged statement made before the police under 161 that we have paid bribes. And in my lord,
Please come again.
my lord, in this case, if your lordship will see, it's a case where reliance was placed on police diary, the entire police diary, for whatever purpose, will not be relevant.
Yes.
In our case, it is the diary which was produced, statement under 161 was produced. And this is an admitted position in paragraph 41 of the state AO at page 159.
Yes.
My lord, Joginder Singh case was placed. I had not placed it in my opening argument because I thought it will come from them. Joginder Singh is at page 241 of the compilation, my lord, this compilation. Your lordship will kindly take. This is important. After this, my lord, just one more thing and I'll end my. My learned friend Miller placed paragraph 14, paragraph 14, 18, and 20. I am placing, my lord. Paragraph 14 says that it is the committee consisting of 3 High Court judges who identified the tented and non-tented candidates. In paragraph 14,
Mr. Kohli had placed which paragraphs? 14, 15 and
14, my lord.
14,
14, 18, and 20.
Yes. And you had cited 14 and 45.
I am citing, my lord. Yes, earlier. Now, what is left is paragraph 14 itself shows that the segregation between tented and non-tented candidate was done by 3 judges committee consisting of the High Court judges. If your lordship will kindly come to 18 now, because paragraph 19 was skipped. 18, in my compilation, it is at page 249.
Yes.
18, there is a chart, you know, then above that it is the particular of the candidates who are facing criminal charges are under. Then 19 says, as far as these cases are concerned, they hardly pose any challenge.
Yes.
As it is specifically found that the aforesaid persons have indulged in unfair means and have been selected either by paying bribe or because of other extraneous reasons and not on their merit, the writ petitions have been rightly dismissed by the High Court. My lord, I'm asking a question to myself, who has found out? The committee, not the police. Because if the police was to be relied, Amarveer Singh first would have been upheld and the entire selection is cancelled. But in my lord, Kohli's case, the court said no. Let it go to the committee, let the High Court constitute committee, and they will decide who is tented, who is not tented. Now, I'll take your lordships to paragraph 26. 26 and 27. Page 251. The report
Yes.
The report starts with noticing the directives of this court in Indrapreet Singh Kehlon. It is specifically mentioned that to implement the direction contained in the said judgment, the then acting Chief Justice has constituted a committee of 3 judges to submit a report on the basis of investigation carried out by the officers of the state government so as to separate tented candidates and from non-tented candidates selected to executive posts by Punjab Police Public Service Commission during the chairmanship of Ravinderpal Singh Sidhu. Thus, the committee knew the scope of exercise which it was carrying out, namely to separate the tented and non-tented candidate. This aspect, therefore, thereafter gone into depth in detail with deft scrutiny. Your lordship, kindly mark it. It was not merely on the police report. With in-depth scrutiny and analysis of record and material placed before it, which not only pertain to the selection process, that is question answer, but also records which surfaced during the investigation into FIR filed against Mr. Sidhu and other person, including some of those who were selected candidates. No doubt it was a mammoth task, and it goes to the credit of the committee that it could successfully achieve that. After detailed and thorough analysis of the individually, the committee was able to separate grain from the chaff notwithstanding some handicap which came in its way. Now, my lord, it is not on the police report itself. Otherwise, my lord, an investigating officer will decide the fate. Then, my lord, another thing which is not my point, but since it was argued by Mr. Kohli, and he has placed the entire framing of charge before your lordship. And according to me, my lord, placing of the entire charge sheet before your lordship was for the purpose to prejudice the court. There cannot be any other reason. Your lordship will not consider whether there was prima facie case or not. That is a separate thing altogether and will be decided in the criminal proceedings. And the impugned order of discharge has to be, my lord, defended on the basis of documents which were available at the time when it was passed, not by subsequently taking into consideration the discharge order or any other thing. And there's a very old case and famous case which everybody knows is Commissioner of Police Bombay versus Gordhan Das Banji. Paragraph 14, my lord. I have sent it, my lord. My learned friend will hand over the page card. This is 9. Your lordship will come to paragraph 14. An attempt was made by referring to commissioner's affidavit to show that this was really an order of cancellation made by him and that the order was his order and that not of that government. We are clear that public orders publicly made in exercise of a statutory authority cannot be construed in the light of explanation subsequently given by the officer making the order of what he meant or what was in his mind or what he intended to do. Public orders made by the public authority are meant to have public effect and are intended to affect the acting and conduct of those who they are addressed and must be construed objectively with reference to the language used in the order itself. So, my lord, the impugned order of discharge has to be considered in accordance with the prevailing situation, the documents which were before the authority. That will be relevant, not the subsequent action of framing charge and then wherein, my lord, the certain prejudicial remarks must have been made because the charges have been framed. Your lordship will not look into that at all. This is my humble request. Now, my lord, having said that, I have come to an end. I'm grateful to your lordships. Lordships heard me.
My lord, if my friend Mishra has completed, then I would like to give my reply, my lord.
You have to squeeze your time.
Yes, yes. My lord, I'll take half an hour. I would request Mr. Mishra to be on the line for some times because I'll slightly disagree with him on a particular point. That's why.
You'll have to make it by 15 minutes because at 3:30 will be.
Okay, I'll do, my lord. I'll do.
The 3:30 will be.
Yes, yes.
We'll run it out later on.
Yes.
You tell me why you did not agree.
No, no, I'll tell you. My lord, Our case is very simple. Now, please come to, Lordships, while opening my argument, I made my lead argument in item number 45, that is writ appeal number 101 of 2020. As far as ACS is concerned, and for APS, I argued in item number 52, that is writ appeal number 126 of 2020. In addition to this, my lord, I'm also appearing in two other matters, that is item number 58. It pertains to labor inspector.
It is writ appeal number
Writ appeal number 154 of 2020.
154.
Yes, my lord. That is a labor inspector matter. And my lord, item number 88, that is writ appeal number 335 of 2023. He is an excise inspector.
What was the first one you referred to?
Writ appeal number 101 of 2020, my lord. That is item number 45.
This is what
ACS. ACS.
ACS.
Yes.
So 1 and 2 are ACS.
No, my lord. Yes, 1 and 2 are ACS. 45 and 46 is ACS where I appear. Item 52, 54 are APS. Sorry, my lord. Item number 52 is
labor
ACS.
and excise.
My lord.
Labor and excise. 154 is labor. 335 is excise.
Yes, writ appeal 154 is labor. Item 58.
Okay, so which was the third one?
Third one is, my lord, item number 88, serial number of the list. Writ appeal number 335 of 2023.
That
He
is
is an excise inspector.
Yes.
Yes.
You said 3 ACS. One is
3 ACS, 1
126.
APS, 1 labor inspector, 1 excise inspector.
Right.
Yes. My lord, the difference in rules are, in case of ACS, it is rule 20C. In case of APS, it is rule 16B. In case of excise inspector, it is rule 19.2. And in case of excise inspector, it is rule 13C. Now, my lord, I'll request your lordships to kindly have the paper book of item number 45. There I'll just refer to the, my lord, rules, what I argued and what the single judge has held. Then I'll come to Mr. Kohli's point. My lord, writ appeal number 101 of 2020. My lord, rule 20, I have supplied the copy of the rules, my lord, that Assam Civil Service Rules 1998. Rule 20C is the relevant rules. If your lordships would kindly have the rules, my lord.
Yes. Yes, please tell us, because
Yes. My lord, the rule 20 reads like this: a member of service shall be liable to be discharged from service. My lord, it speaks a member of service. That means one who has already entered service. If any information received relating to his integrity, age, health, character, and antecedent, the governor is satisfied that the probationer is ineligible or otherwise unfit for being a member of the service. My lord, my humble understanding of this Rule 20C is very simple. It can be applied to a member of service, irrespective of whether, my lord, he is at the stage of pre-recruitment or post-recruitment. One can become a member of service only post his recruitment. Therefore, the argument of Mr. Kohli that this concept of motive and foundation would be applicable only to a person who is recruited to service and not to a person who is found guilty of making some or adopting some unfair means in selection, my lord, it all loses its relevance. It's very clear, a member of service. If you want to discharge somebody whom you can, it is the member of service. When can I become a member of service? Only when I'm recruited to the service. So there is no dispute that I'm recruited to the service. Now, my lord, the second point is information. Now, what we argued, whether this police report can constitute information, requisite information necessary to invoke Section 20C. It is in that context, my lord, we said, we also relied upon the line of authorities where Supreme Court has said, if there is even a live connection between the alleged misconduct and the termination of provisioner, then it will still amount to termination. Therefore, 311 will be attracted. Now, my lord, to bring home my point, please come to page number 248 of the paper book of the impugned judgment, which has been accepted by the single judge, learned single judge. Page 248, para 7. Before the learned single judge also, I opened up the argument, my lord. That's why it is recorded in seriatim. If your lordship has got it, can I read it, my lord? Page
Yes.
248, para 7.
Yes.
The thrust of K. N. Chaudhary's submission is that if on the attending facts and circumstances, the impugned order of discharge is seen to be based on alleged misconduct, or if a live connection or nexus is seen to exist between allegations of misconduct and discharge, then the same, even if couched in a language which may not appear to be stigmatic, would amount to punishment for which a departmental inquiry would be imperative. Referring to para 7 to 17 of the affidavit in opposition dated so-and-so, filed by the state in WPC number so-and-so, submission made is that it is clear therefrom as to what propelled the respondent to discharge the petitioner, which came in the guise of order under Rule 20C of the 1998 rules. Similarly, reference is also made to the stand of the state respondents that also in respect of the charge of the petitioner employed in Assam Police Service, the same was based on allegation of misconduct, although shrouded in an innocuous looking order under order Rule 16B of the 1966 rules. Thus, pinpointed argument is that the very foundation for taking recourse to Rule 20C or Rule 16B is clearly the investigation carried out by Dibrugarh Police. It is contended that condemning the petitioner on the basis of the police investigation is a travesty of justice. Further, it is only on the presumption that petitioners are sought to be victimized, inasmuch as allegations are yet to be established before the competent authority in accordance with law. Referring to the relevant rules envisaging discharge of a provisioner from service, it is stated that condition precedent for invoking the same is satisfaction of the governor, which must be on an objective criteria based on relevant material and concrete evidence. It is submitted that recourse to such rule cannot be in an ipsit-dixit manner, that is on the mere saying of the respondent. By referring to paragraph 7 of the affidavit in opposition dated so-and-so of the state respondent, it is stated that it is apparent therefrom that conscious decision taken to discharge the petitioner was only on the basis of the report of the Dibrugarh Police. Now, my lord will kindly come to the same judgment at paragraph page number 281. Para 47. Now, there is no appeal by the state against this. I do not know what they are arguing, my lord. Kindly compare to para 47. page 281. Indeed, there can be no hiding from the fact that the arrest and the materials collected against the petitioner following the FIR dated 27/10/16 registered as Dibrugarh PS case number so-and-so had set the ball rolling. So the learned single judge also candidly admits that it is the information contained in the case diary or the statements made under 161 are the basis for taking the impugned action. The investigation report of Dibrugarh police were foundational facts, the gravity of which was considered by the government of Assam in personnel department, which eventually resulted in the impugned orders being passed, preceded by a consultant with the concerned department, obtaining the views of the judicial department, and with the approval of the highest governmental authority. The impugned actions are only in respect of an undue, etc., etc., etc. So, my lord, the learned single judge agrees with us that it is the information contained in the Dibrugarh police station case diary that had propelled the state to take the impugned action. That was our case. Now, my lord, to bring home the point that even a police report also can form basis, they relied upon the two judgments, Krishna Yadav and, my lord, O Chakradhar. My lord, there I said my friend Mr. would be there. I have a slight disagreement with him on a particular point. While referring to Khatri, my learned friend, my esteemed colleague, Mr. Mishra has said that was a case, certain informations were contained in a CD. Ours is a case where we are concerned with the statement made under 161. I have my doubts about what my learned friend said. According to me, my lord, statement recorded under 161 are contained in a CD only. Therefore, perhaps we cannot make a distinction between a statement under 161 and a CD. End of the day, in Khatri, Supreme Court says, in a proceeding under Article 32 or under 226, it would be relevant only if it is otherwise admissible under the Evidence Act. Now, that is what Section 33 provides of the Evidence Act. Now, these are untested informations. So therefore, my lord, all that we are saying is the expression information contained in all the different service rule, it has got a definite legal connotation. It must be an information which must be objective. It must inspire the confidence of the court. Now, why I refer to Joginder Pal and Inderpreet Kehlon? Because unlike in the present case, in Inderpreet Kehlon and Joginder Pal, my lord, there were materials in the form of a 3 honorable judges committee recommendation where they pointed out illegalities. My lord, it is not our case that what they are alleging is something which cannot be examined by the authority. They can. Let them proceed against us departmentally. Let them suspend us, hang us, but not in the manner they have done it. For a moment, we are not saying, if your lordships allows our writ appeals by interfering with the learned single judge's order, it does not mean that state cannot take action against us. No, that is not our case. Our case is, my lord, the protection which is afforded by Article 14 and 16, it is not confined to only our entry level. The protection under Article 14 and 16 continues, my lord, until I superannuate. There I rely upon that Beliapas case, my lord, where the Honorable Supreme Court says these 3 articles, Article 14, 15, and 16, these are the equality clauses. As far as a person who is in government service, the protection under these 3 articles is not confined to his entry level. It continues. So, my lord, we were recruited to different services. Now we are sought to be discharged on the plea that there are certain allegations against us. Very well, you may be right. Your comprehension may be absolutely correct. But there is a particular manner in which you can take action against us. That manner you have not followed. That's why we are before your lordships. And in our humble submission, my lord, the learned single judge failed to appreciate. My lord, in para 47, learned single judge admits that other than the Dibrugarh police station report, there is nothing else. If there is nothing else, how the action was upheld? My lord, this concept of, my lord, initially it all started with that if the action is based on a motive, then it would be a termination simpliciter. Then if it is founded on an allegation, then it would be foundation, in which case Article 311 would be attracted. As pointed out by my friend, Mr. Mishra Miller, over a period of time, the law, as it evolved, my lord, that concept of live connection between the misconduct and the termination has been developed. And last of the authority, my lord, where this point has been emphasized by the Supreme Court is that Mahavir's case, my lords, 2010 8 SCC 220. 2010 8 SCC 220, Union of Indian Others versus Mahavir C. Singhvi. My lord, I'll have your lordship's kind attention to para 41 of the judgment.
2010 8 SCC page
220, my lord.
paragraph.
Paragraph 41.
Yes, please read.
Mr. Bhushan submitted, as has been rightly held by the High Court, the case of the respondent was fully covered by the series of decisions of this court, which have been referred to on behalf of the petitioners. Mr. Bhushan, however, laid special emphasis on the following decisions of this court, some of which have been cited on behalf of the petitioners, namely State of Bihar versus Sif Bhikshuk Mishra, Samser Singh, Gujarat Steel Tubes, Anup Jaiswal, Nehru Yuvak Kendra, etc., wherein it has been repeatedly observed if a discharge is based upon a misconduct, or if there is a live connection between the allegations of misconduct and discharge, then same, even if couched in a language which is not stigmatic, would amount to a punishment for which a departmental inquiry was imperative. Various other decisions were also cited by Bhushan, which reflect the same view as expressed by this court in the above mentioned cases. So this is a concept, my lord, which came to be developed little later, but now it is firmly well settled that if there is a live connection between the alleged misconduct and the discharge, then it will be a punishment. Therefore, a departmental inquiry is a must. My lord, read with Rule 20C, where it refers to member of service. Therefore, the entire emphasis of the learned single judge to say that's in all the decisions we cited, this all pertains to misconduct conducted post-recruitment, well, it is of no avail. It's absolutely, my lord, wrong understanding of the legal position, my lord. The position is very clear. End of the day, my lord, a judgment is an authority for what it actually decides. Now, your lordships will have to take a call in the context of Rule 20C. Rule 20 recognizes me as a member of service. That is why they have invoked Rule 20C. Had it been a case of pre-recruit, then I do not know what would be the rule, my lord. So, my lord, now therefore, Mr. Kohli's attempt to say that there was a detailed investigation, there was a SIT, etc., etc., but this is all in the realm of police investigation. No matter, my lord, whether the investigation is carried by a particular investigating officer or it is conducted by an SIT of 3 IPS officers, it still remains an investigation. It cannot attain the status of a, my lord, administrative report. It is in this context, my lord, we distinguish Krishna Yadav and O Chakradhar. My lord, lordship, my learned friend Mishra has already placed the facts of those two cases. My lord, I distinguish those two cases on one particular point. My perspective was that these are the two cases where on the administrative side, there were materials before the authority in the form of a preliminary report of the CBI. In Krishna Yadav, my lord, which was followed in Chakradhar, there was a direction by the Supreme Court whereby CBI was directed to conduct a preliminary inquiry. Under the CBI manual, Lordship knows CBI will initially conduct a preliminary inquiry. If they find materials, then they will register a regular inquiry. From Milord Krishna Yadav and Chakradhar, it does not appear, at least there is no mention, there is no recital that it was followed by registration of a regular inquiry. Therefore, we cannot say that it is a police investigation. When we say police investigation under CRPC, it has got a definite legal connotation. So, my lord, Chakradhar and Krishna Yadav are distinguishable because there, like Joginder Pal and Inderpreet Kahlon, there were reports in the form of an administrative reports, which can form basis for the purpose of deriving the satisfaction under Rule 20C. Unlike, my lord, in our case, where there is nothing other than some 161 statement and some materials in the CD, those informations are yet to see the light of the day. Therefore, my lord, where is the scope? So our contention is very simple. We say that if you have any material, please proceed against us departmentally, give us a show cause notice. All right, if you feel that our continuance is served, then place me under suspension. Proceed against us. Hold us guilty. Criminally also hold us guilty, then send us to jail. But not in the manner you have done it. This is perhaps could not be done. Now, Lord, I was referring to that Beliappa's case.
We'll have to rise because.
Yes, my lord. I'll wind up, my lord. Lord, will kindly give me 2 minutes time. My lord, I'm sorry, my lord. I'll just take 5 minutes time if your lordship kindly permits. 1979, 1 SCC 477.
1979?
1979, 1 SCC 477. I think book list has been given, my lord. I'll have your lordship's kind attention to para 18 and 19, but I'll not read 18, I'll read para 19, my lord.
Yes.
It is now well settled that the expression matters relating to employment used in Article 16(1) is not confined to initial matters prior to the act of employment, but comprehends all matters in relation to employment, both prior and subsequent to employment, which are incidental to employment and form part of the terms and conditions of such employment, such as provision as to salary, increment, leave, gratuity, pension, age of superannuation, promotion, and even termination of employment. It is further well settled that Article 14, 15(1), and 16(1) form part of the same constitutional code of guarantee and supplement each other, if any of etc., etc. So, my lord, the guarantee under 14, 15, and 16 is not confined to only the recruitment stage. It also contains, it also includes guarantee post-recruitment until even termination. My lord, finally, in the APS matters, my lord, there was an interim order. While passing that interim order, if your lordships would kindly have the paper book of item number 52, my lord, just 2 minutes time, my lord. Item number 52, writ appeal number 126 of 20, where the learned single judge has recorded a finding, my lord, while passing the interim order. That is very important in our humble submission, my lord. I'll just read 2 paragraphs, my lord. Paragraph 5 and 6 at page 200. Where learned single judge, while considering the interim prayer in APS matters, my lord, had the occasion to call for the records, and from the records what transpired, it has been recorded in the learned single judge's order.
Yes.
R.K. Devchaudhary, learned additional senior government advocate Assam, has accordingly produced the relevant file today dealing with the issuance of the aforesaid discharge order. This court has gone through the said file. Relevant parts of that file indicate that authorities relied upon investigation undertaken by police in connection with the related criminal case to come to the conclusion that petitioner had secured appointment by engaging in fraudulent act by placing answer script in connivance with the then chairman of the Assam Public Service Commission. However, on queried by this court, it has been clarified by the learned senior government advocate that finding of the police is based on charge sheet being submitted before the criminal court, though the trial court has not yet commenced the said case. In other words, the aforesaid finding of fraudulent activity alleged to have been committed by the petitioner is a matter which is yet to be proved in a court of law, and it is merely at the stage of charge which is yet to be conclusively established in accordance with law. However, authorities by relying upon the said charge sheet has come to a definite conclusion that petitioner had obtained appointment by fraudulent means, because of which authority came to the conclusion that petitioner is unsuitable to be retained in service. Therefore, said charge is yet to be established and proved in accordance with law. Therefore, it cannot be also said that these are established facts. What Rule 16b contemplates is taking of certain adverse action on certain established fact, or not on mere presumption and assumption, howsoever genuine they may appear to be, which renders the continuance of the employees untenable as unsustainable. So in my humble submission, my lord, though this is an interim order, my lord, it has got a lot of bearing in adjudication of the issues involved in this case. So I'll respectfully submit, my lord, lordships will take due note of these facts. Where the learned single judge, while passing interim order in IPS matters, my lord, recorded this finding. State never filed any appeal against this order, my lord. So learned single judge, while at the interim stage was of the conclusive view, my lord, established fact, this police report cannot constitute established fact, which is a point which we are projecting all throughout, my lord, and even today. And my lord, we also filed written argument before the learned single judge, which have annexed in all the papal memos, have taken all these points, my lord. Therefore, my lord, to conclude, my lord, our case is very simple. Information or established fact, whatever the expressions used in the respective service rule, would mean something which cannot constitute a police report. Therefore, the premise on which the foundation of the state's case, stands, is something which cannot withstand judicial scrutiny. Lord, yes, it could be my lord, and my lord, public interest is not a one-way traffic. While trying to achieve public interest, one cannot be denied procedural safeguards. My lord, end of the day, what we are assailing is the decision-making process. We are not on the power of the state to discharge a government servant. You may have the power. You may have the power to terminate also. We are not questioning that. We are questioning the manner in which you have done it. Whether the manner which you have adopted is something which can withstand judicial scrutiny. My humble submission is, my lord, it cannot. Therefore, my lord, it's a pure and simple case. In para 47 of the impugned judgment, the learned single judge has come to the conclusion that the ball started rolling from the Dibrugarh police station case report. And the state has not filed any appeal against that. That finding has attained finality. Therefore, my lord, taking a clue from the learned single judge's order, my humble submission is all these writ appeals are liable to be allowed by interfering with the order of the learned single judge. That's my humble submission, my lord.
In paragraph 41 at page 159, the state says they handed over the statements. They don't say diary or they don't say the 161 statement. They say just they have handed over. So that way, I was meaning that 161 statement was given. It is 159
Anyway,
at 159.
Okay. We'll record the names of the senior counsel and counsel for the appellants first, and then say the reply submissions by Mr. D. K. Mishra, senior counsel, assisted by Mr. D. Prasad, and counsel for the appellants in so, as well as by Mr. K. N. Chaudhary, senior counsel, assisted by Mr.
J. Patwari, my lord.
J. Patwari, and counsel, the appellants in so. Mr. Chaudhary's cases are WA 101 of 2020, 126 of 2020, 154 of 2020, and 335 of 2023. Just make it Monday, 16 for reply submissions by senior counsel of the counsel by other appellants.
Lordship, if I'm also available online, Lordship, Monday we'll be there. Lordship would be keeping it at 2 p.m. only. I'm sorry to ask, but
we don't know the.
I know.
List with the board members. It depends
Hello,
on.
there is no question of reply. Otherwise, there will be no end to it.
No, Mr. Kohli is not saying reply to reply. He says he is present.
Okay.
No, Mr. Chaudhary, I was only asking if it is at 2 o'clock or not.
Okay. I thought that otherwise there will be no end to it.
No.
Guys, we have to give Lordship some time to write the judgment. I am aware of that.
Mr. N. Kohli, Leonard, senior counsel, for the senior counsel, assisted by Mr. S.K. Hazarika, government advocate, who is appears through video conferencing.
And Lordship, I'll request for Mr. A. Roy and Miss Nimisha Menon
Yes, those
from the
names.
old orders.
Yes.
I'm grateful.
Okay. This was okay.